LSE. My name is David Kershaw. I'm the Dean of LSE Law School. And welcome to this wonderful launch event that we have tonight for the London University Council of Academic Freedom. Bit of a mouthful, we'll go for LUCAF, I think that makes life a bit easier. Professor Ian Pace, Professor of Music, Society and Culture at City, will say a few words about LUCAF. And then we have our wonderful speaker tonight, Aqua Reindorf, KC, who I will introduce once Ian said a few words about the council. Ian, over to you.
Thanks very much. So, Professor Kershaw said, I'm Ian Pace, I'm Professor of Music, Culture and Society at City, University of London, and founding member and secretary of what I'm going to call just LUCAF from now on, as it is quite a mouthful. To say first, it's really immense pleasure to see so many of you here for this event, which combines the launch of the new organisation with this vital talk on academic freedom and freedom for harassment in universities by Aqua Reindorf, KC, which I'll hand over in a moment, but also to thank LSE and thank you and everyone involved in making this possible and hosting this event. LUCAF came about as an initiative earlier this year from several London academics working in diverse fields who all perceived the need for a new organisation that was non-aligned. It was not linked to other groups or to other sources of funding, and which could welcome and accommodate academics of a wide range of ideological, disciplinary and political perspectives. It would be focused on London institutions in order to be large but manageable, and would bring together wide-ranging expertise, knowledge and insight to produce scholarly work on many related issues in order to feed into policies of both academic and governmental institutions. From an initial core of around 20 founding members from a range of institutions, we now have well over 100, but are naturally always encouraging others to join and contribute. There are three founding principles behind LUCAF, which are worth repeating now, and they're detailed up here on the website. They're free inquiry, intellectual diversity, and civil discourse. By free inquiry in particular, we mean the exercise of academic freedom within the law in all areas of teaching, research, artistic expression, and speech. And you can find more information about our principles and our activities on our website here. In terms of our work and activities, we're not a group who will be issuing views on every ongoing incident relating to academic freedom as and when it occurs, or taking up individual cases. There are other groups who do that perfectly well. Rather, we are looking for more considered knowledge development on all areas of academic freedom, and we've been setting up working groups to do this. We will be intervening in a more strategic way, developing policy and responding to consultations in order to centre the value of academic freedom in higher education. As an example of this, we're currently developing a response to proposals for the 2028 Research Excellence Framework, which can be viewed in still a draft form on the policies page, which you can click at on the top of the website. So please do check this out. And there's still a day to contribute any thoughts to it, and then we'll be taking signatures. Academic freedom is at the very heart of what makes universities what they are. Spaces in which scholars can challenge orthodoxies, explore new knowledge, develop thought free from external or internal interference. If you agree and support the founding principles, please do sign up. We admit and welcome academic staff, professional staff, students and alumni. And we'd be especially keen to welcome more members from a wider range of London institutions beyond those already represented, including specialised institutions in particular disciplines, and to further broaden the range of discipline represented amongst our members. So that's all I have to say for now, and then I want to hand over for the main part of the event. But just finally, to point out that a significant number of founding members are here tonight, mostly sitting around here, and all wearing badges. So if you want to know more about LUCAF, please do catch one of us after the talk, and we'll all be happy to answer further questions. Thank you.
Thank Thanks so much, Ian. So it's my privilege to be able to chair this event tonight, and my privilege to be able to introduce our speaker for this evening, Aqua Reindorf, KC. As many of you will know, Aqua is one of the country's leading employment discrimination and human rights barristers. She has a long list of accolades to her name, and I'm not going to take you through them all, but I'll just mention a couple of them. She was appointed as a commissioner of the Equality and Human Rights Commission in 2021. She was the country's leading employment law junior in 2022, and in 2023, the Legal Business Awards made her the Barrister of the Year. In 2023, she was appointed a KC this year, so congratulations. And as of course we all know, there's no better person, I think, to start a conversation and to launch LUCAV than Aqua, because she has a very significant practice advising universities on academic freedom, on speech and harassment. So colleagues, without further ado, please join me in welcoming Aqua Lizzie.
Thank you very much, everyone. Sorry, I hope you'll forgive me for not standing up as I'll fall over, not least because I've got to hold this computer. I am extremely honoured to be asked to speak at this launch of this important new venture. It's really, really great to see another academic freedom organisation coming to life. It feels like it's every week that we see a new branch of Academics for Academic Freedom, and I think this new collaboration, whilst it has a different focus, will be complementary and extremely valuable. And you have some of the most dogged and doughty campaigners on board, looking at Alice over there. So I'm sure that you will go from strength to strength. Just a little bit of housekeeping. Even though I am a commissioner of the EHRC, I'm not here in that capacity, and I'm not here in any other capacity other than as a barrister. And also the other thing is that I always have to say is my voice tends to go croaky after I have been going on for a bit, which is nothing to worry about, it's just a bit annoying. So what I'm going to talk about this evening in quite broad terms is academic freedom and freedom from harassment in higher education, in the context of an exploration of how well those sort of legal areas of legal inquiry mediate the clash that we have between different systems of thought and ways of understanding the world, which seem to lie at the heart of the current threats to academic freedom or freedom of academic inquiry, and how the law might do that best in the future, how it might mediate that conflict best in the future. Academic freedom as a concept has been around since a time when it was less controversial than it is now to say that the essential foundation of a university was to pursue and disseminate knowledge and truth. It emerged in the early part of the last century as a rationale for getting rid of interference from the church first and then the state later on in the work of academics. And it was described explicitly at that time as having the purpose of enabling academics to devote themselves to the discovery of truth without meddling and interference from those to whom they were beholden, the church, the state, funders, whoever. The American Association of University Professors issued a declaration on the principles of academic freedom in 1915, which said that academics were men, obviously, trained for and dedicated to the quest for truth, who were engaged in the gradual wresting from nature of her intimate secrets. And the Magna Charta whatever it is in Latin, Universitatem Chartarum, I never know, in 1988, much more recently, talks of academic freedom as the constant, talks of the constant care of the university being to attain universal knowledge. That bit has gone actually from the latest iteration of the Magna Charta, which might give you a clue as to where the fault lines are that I'm going to be exploring. The classical model of academic freedom is that the way in which academics pursue knowledge and truth is by engaging in contestation disputation, challenging orthodoxies, testing truth claims by systematically and scientifically applying logic and reason. I don't know who it was who said, he who only knows his side of the argument knows little of that. But it's quite pithy and it works to sort of sum it up. And you know, overall, it's hard to imagine a more Enlightenment-inspired paradigm, and it's a paradigm which persists more or less in the same terms today. It's still based on the principles set out in the AAUP Declaration, which has three strands: freedom of inquiry and research, freedom of teaching within the university or college, and freedom of extramural utterances and action. And today the focus still remains on prohibiting adverse consequences for challenging received wisdom or established doctrine. And although academic freedom has its roots in sort of classical liberalism, it also has in the past been claimed by those on the left of politics, very much like the principles of freedom of expression and freedom of conscience, on which, or to which it's very closely related. Freedom of expression and freedom of conscience were the preserve of the left until about 5 minutes ago, in my memory anyway. Think of Amnesty International campaigning for prisoners of conscience, and that was their raison d'etre when they started up, and the UCLA in the States defending the free speech rights of the Ku Klux Klan, purely on the basis that it was important to uphold the overriding principle that freedom of conscience and freedom of expression are universal human rights. And after the student protests of the late 60s in this very school, the Council for Academic Freedom and Democracy was born. Ralph Miliband, the man who hated Britain, we'll remember that, was founding member, and Noam Chomsky was a patron, so we can safely say that was a securely left-wing organisation emerging out of the sort of part of the free speech tradition, the part of the free speech tradition that particularly values the freedom to protest, which is an essential part of the package, subject to the unacceptability of the heckler's veto. So that's the sort of past of academic freedom. I'm not the first, and I'm sure I won't be the last person to note that the most recent threat to academic freedom doesn't come from the church or the state or the right wing, but from within the academy itself. We're seeing a steady stream of cases where academics with ideas which are deemed heretical are being subjected to varying degrees of bullying and persecution, from the insidious and the attritional right up to being hounded out of their institutions by organised campaigns of intimidation with completely balaclavaed men and smoke bombs. And the people doing it are students and colleagues. And the stated reason that they're doing it is almost always something to do with the views of the individual with whom they take exception about a purportedly marginalised group. It could be said to some extent that there was a foreshadowing of this in the 1960s protests that I've just made reference to. The protest here at LSE was about the appointment of the Rhodesian Walter Adams as director of the school, and the students had a sit-in under a banner that said, "Beware the pedagogic gerontocracy," which, I mean, I have to say that the standards, the banner skills have deteriorated. Because I saw the other day on Twitter a banner where somebody holding up just a scrap of cardboard with the legend "microwave oven" written on it. So sad to see this drop in standards, but apart from that, there do seem to be on the face of it some parallels. It's not just that there are young people protesting against the old. That's, you know, all is right in the world if that's what's happening. What's more pertinent is that those protests in the 60s involved, or that particular one involved students objecting to the presence of a member of just the presence of a member of academic staff, because he was perceived to be complicit with racism. So it looks at first blush like an attempted cancellation for guilt by association, which will be something that sounds very familiar. But I think on closer examination that the similarities between the student protests of the 60s that were rooted in the civil rights movement and today's cancel culture is actually fairly superficial, because those protests happened well before identity politics, or what's become known as woke ideology, were conceptualised. And that's where, you know, we come to the heart of the matter, the driving force of today's activism. Like a lot of people who come from the political left, I'm really, you know, I have a real tribal resistance to whinging about wokeism and criticising woke ideology. I find it difficult to even use the word, so I'm not going to use it again. And what I'm going to call it is contemporary activism, which is a dreadful phrase, but it's all I could come up with today, so that's what I'm going to say. But whatever I call it, it's inescapable that it's at the heart of the current crisis for academic freedom, and it's inescapable that, depressingly, it's people who purport to be on the left who are vociferously opposing freedom of expression, freedom of conscience and academic freedom in the name of left-wing politics and principles, and that those who are opposing them are mainly on the right. You know, those are the facts. And it's something that people on the left have to grapple with, is a sense of slight ickiness about who the fellow travellers might be on this journey. But it turns out, actually, I've found some personal growth in this, and it's actually a really valuable exercise that helps you draw your own boundaries and connect with other people's humanity. So all's well ends well. But there we are. I started this talk on the premise of academic freedom as an essential component in the pursuit of knowledge and truth in the academy. And it's clear that those who are agitating against freedom of speech and academic freedom are very often motivated by a way of thinking which has flourished in universities in particular over the last 30 years or so, which rejects entirely the idea that academic inquiry is anything to do with the pursuit of knowledge or truth. So it's pretty obvious as well that that's where the schism is here. That's what gives contemporary activism, remember that's what I'm calling the W word, is a quite different, it's a quite different flavour of activism to what was happening in the 60s because of that. This is an ideology that doesn't accept that there's an objective truth for academics to pursue, and it's based on the idea that all there is power. And the power is constructed through discourse and language and serves to entrench privilege and oppress the marginalised. So Foucault, of course, said power produces reality, it produces domains of objects and rituals of truth. That's the sort of idea that sort of filtered through Twitter we are now dealing with. And it's this way of thinking, since language is the locus of the oppression of the marginalised, in this way of thinking, it follows that the marginalised are liberated or achieve justice by the silencing of the language that oppresses them, that perpetuates the harms against them. So the aim of this sort of activism, rather than pursuing truth and knowledge, is to disrupt and destabilise these discourses that entrench privilege and power. So, you know, in case you're wondering, yes, I did go to Sussex. I did read a lot of Foucault. It's pretty much all I read in the 5 years that I was there. It's a very long time ago, and I'm pretty rusty on it, but it doesn't seem to have come on very much, I have to say, in the 35 years that have passed. And I enjoyed it. It's a way of thinking that is very attractive to young people who are at the, what is truth anyway stage of their lives. And it's very seductive and flattering because it elevates subjective lived experience to the same level of validity as any other way of knowing about the world. But, even then, I did quite soon realise that it just isn't a way to live a life, because ultimately, you still have to get on the plane, even while you're contemplating that it might be a discursively produced social construct. So, and not only that, but the theory itself rests on an appeal to its own unassailable truth, and it doesn't have any moorings within it to validate that claim to authoritative meaning. So it's completely incoherent and illogical. But even beyond that, it doesn't even care that it's incoherent and illogical, because it doesn't see coherence and logic as tools for discovering meaning or reality or truth. Foucault again, reason is merely instrument and expression of power. It sees logic and coherence as discursive manifestations of power and privilege, for instance, as white supremacy. So ultimately, the whole thing just keeps slipping through your fingers. You can't get any purchase on it, and you might as well argue with the kettle as try to reach a consensus on any basic facts with people who subscribe. I'm sure there'll be people here who subscribe to that and can challenge me on it, but we'll see. So at the extremes of this sort of epistemological battle, we have on the one hand people who feel that you can plod your way through towards enlightenment by using the scientific method, just as long as you're left alone to get on with it. And then on the other side you have, and I'm talking about at the extremes here, people who want to just throw away all the accumulated body of scholarship, silence its proponents, and replace it with the unassailable lived experience of the marginalised, perhaps best characterised as feelings don't care about your facts. So it's no wonder that really there's a lot of talking past each other, and this seems such an intractable conflict, because it just isn't a shared frame of reference. So that's the background against which I want to talk about how the law travels this terrain. The question for me really is, how do universities manage the disconnect between their legal obligations and the epistemological framework within which many of their members operate? The law is very messy, unfortunately, in this area. We have laws which protect speech, and we have laws which protect people from speech. Laws which protect speech include the law of academic freedom in domestic law, now contained in the Higher Education Freedom of Speech Act, which is not yet in force but will be next year. We have the law of freedom of speech and freedom of thought, conscience and religion in the Human Rights Act, which comes from the European Convention on Human Rights, which is implemented through the Human Rights Act in our law. And we have protection from discrimination because of philosophical belief in the Equality Act. Those are three main things. There are others. I'm just mentioning some. And some of the laws which protect people from speech include the law of harassment related to a protected characteristic in the Equality Act, discrimination law more generally in the Equality Act, the law of civil and criminal harassment and protection from harassment Act 1997. We have defamation law, and we have a sundry collection of criminal offences like incitement to hatred on grounds of race, religion or sexual orientation, sending malicious communications, and we have some use of threatening, abusive or insulting words or behaviour in particular circumstances, sort of stirring up a type of offences. There are others. But importantly, what we don't have at the moment in this country is, in force in this country, is a law of hate speech, a law that's called hate speech. The nearest we get to that is hostility relating to one of a few protected characteristics which can be used as a sentence aggravator or enhancer in criminal offences, but it has to be a prior offence, which is then aggravated by hostility because of a protected characteristic. And we have the stirring up offences. Although we don't have a hate speech law, what we do bizarrely have is the infamous non-crime hate incidents. But I'm not going to say more about those because I just can't bear to, frankly. The law. So those are the sorts of causes of action that we have, which are relevant in this area. And what I think is important to understand about how they are used in the university context is that, like the classic model of academic freedom that I talked about earlier, the law is on the whole still anchored in the idea that we have a shared frame of reference within which we can access objective truth, and we can discern the motivations of individuals, and we can make reliable judgments about what's reasonable and what isn't reasonable. And judicial decision-making still aims to find facts and make judgments about motivations and reasonableness. through the examination and testing of evidence. So, from the get-go, the whole thing is much better suited to how academic freedom is conceptualised and articulated than it is to, my phrase again, contemporary activism, W word. Or on the other view, if you're coming from the other side, the law discursively entrenches prevailing power narratives, as you would expect it to. But it is fair to say that the law is far from perfect in that respect, even on its own terms. Reasonableness tests are found in the law, especially in this area, and it's a reasonableness test which is supposed to provide in many causes of action an objective unit of measurement. So judges are often required to answer the question, what would a reasonable person think about this? So in the legal causes of action which protect people from speech, which I mentioned earlier, harassment under the Equality Act only amounts to, well, unintentional harassment only amounts to harassment if it was reasonable for the victim, the purported victim, to experience it as having violated her dignity or keep doing that, one of a number of other effects. That, in fact, is what we call a mixed subjective and objective test, but the reasonableness part of it is the objective bit, allegedly. In direct discrimination, we have a notion of detriment, so you can only get your direct discrimination claim off the ground if you can show that you've been subjected to a detriment. And the definition of a detriment is something that a reasonable person would think in all the circumstances is to their detriment. And under the Protection from Harassment Act, the perpetrator or the alleged perpetrator, this is the act which deals basically with stalking, ought to know that what he's doing amounts to or involves harassment of another if a reasonable person in possession of the same information would think that the course of conduct amounted to harassment of the other. You can see the pattern here. Same in defamation, we have the benchmark for the meaning of allegedly defamatory words is what the reasonable person would understand by the words. And defamatory statements include those which tend to lower a person in the estimation of right-thinking members of the public. So the upshot really here is that these reasonable person or right-thinking member of society tests depend on what sort of person the particular judge thinks is a reasonable person or a right-thinking person in society, really, when it comes down to it. And however formulaic the legal test, and some of them are harassment in particular is very formulaic, there's really very often this kind of fundamental kernel of subjectivity in the supposedly objective part of the test. And what another thing that the law does, which is supposed to, or it is consistent with the way in which, with the sort of classical liberal tradition, is that it encompasses the idea that its response to harmful speech must be proportionate, because it must take into account the rights of speakers and wider society and balance them against the rights of the victim. And I think it does that much more successfully than it does reasonableness, but it's an important factor. On the other side, on the contemporary activism side, these formulations of reasonableness and proportionality just are completely inimical to that way of thinking. What contemporary activism does is it regards as definitive the purported victim's subjective perception that she's suffered harm, and disregards altogether the question of whether the harm was either intended or reasonably experienced. And through that route, the conduct that is being complained about becomes an expression of hate attributed to the perpetrator, but entirely divorced from what the perpetrator meant to do or how other people might interpret what they did. We've all seen, or at least those of us who look at Twitter have all seen mystifying accusations of hate confidently levelled against people who appear to be attempting just to take part in reasoned debate about a contested issue, and accusations of sea lining or just asking questions, which just seem absolutely bizarre. And we've all seen equally mystifying assertions of harm being caused by those apparently reasonable attempts to have a discussion, up to and including genocide. And now the law is not capable of encompassing or accommodating those concepts of hate and harm, because in essence they're just pure thought crime, and we don't do that. You know, we don't have thought crime. Our law doesn't have thought crime, although the Scottish Government have given it a good shot with their Hate Crime and Public Order Scotland Act, passed in 2021 but still not enforced because the police can't work out how to enforce it, which contains a stirring up offence, which just, you know, beyond the pale, although I'm on film, I shouldn't really say that, but anyway. So for Foucault, the only thing which is not power is justice. Note the absence of freedom there. But in contemporary activism, my W word formulation, justice is not proportionate in the way that our system of law aims for. What it is, well, the way it works is that the only just response to hate and harm is to stop it, so that the victim can be safe, and safety being conceptualised as insulation from language that causes psychological discomfort. So, in summary, the law, I think, tries to protect people from speech when and to the extent that it is objectively reasonable to do so, albeit that it's a dubious objectivity. And contemporary activism elevates the harm and hate subjectively perceived by marginalised people into an incontestable truth claim about other people's speech, to which the only just and equitable response is to silence the speaker. I mean, in my view, that is one reason why this is in fact a rampantly individualistic ideology and not left-wing at all. There's no class analysis, and it just focuses exclusively on the integrity of the person without any regard for the effects on wider society. But be that as it may, we can see that the downstream effect of the epistemological conflict that I've talked about between traditional methods of academic and legal inquiry on the one hand and contemporary activism on the other is that we have wildly different frameworks of meaning about words and concepts like harm and hate. That also extends to concepts like safety, inclusion, diversity, equality, equity. I could go on, and I haven't got time to explore those, but I hope you get the idea. And these are all words and concepts that we use to delineate legal rights and obligations, and to describe the aspirations of law and policy. But we're simply not singing from the same hymn sheet when it comes to identifying their significance and applying them to real-life situations. So, what does this all mean for academic freedom and freedom for harassment in universities? I think the bottom line is that both misinformation and disinformation abound about how academic freedom and freedom of speech can be achieved in the academy, while at the same time making sure that it's a place where students and staff can be free of harassment and discrimination. So I will try to put some of that straight, but don't quote me, it's not legal advice. So freedom of speech, freedom of conscience in the European Convention on Human Rights, implemented in our law through the Human Rights Act. I'm starting with this because it's foundational to everything else. Most people, and I'm sure all of you are familiar with the idea that we have a right to freedom of speech in a democracy, and that it comes from international human rights law. Article 10 of the Convention states everybody has the right to freedom of expression. This right shall include freedom to hold opinions and to receive and impart information and ideas without interference by public authority. Famously, it includes the right to offend, because the right to say only inoffensive things is not a right worth having. And most people are also aware that there are limits to that right, although I would say that understanding of where those limits are can be very distinctly hazy, and is in any event movable and difficult to identify. The first important limit is that in our law is that the Human Rights Act only applies to public authorities, and universities are occupy a sort of hybrid position. They're public authorities in some senses, but it's strongly arguable that they're not public authorities when it comes to their relationships with their staff and students. Those are relationships which almost certainly exist in public law. I'm hedging it a bit because I've got to make the opposite argument in a case next year, so I don't want to. I don't want to bind myself. But so the Human Rights Act doesn't, strictly speaking, apply to the relationships immediately between the university and its staff and students in theory. But that doesn't mean that the Human Rights Act isn't relevant in that context, because all it means is that a staff member or a student can't bring a claim directly under the Human Rights Act in court against the university. But if they bring another type of claim, any other type of claim, they can ask the court or tribunal to interpret the law that they are relying on in a way that's compliant with the human rights principles that come from the convention. And I think, it's perhaps the reason why so many advances are made in the courts and tribunals in this area is because it's the judiciary and not the private organisations or the universities or whoever it is that are directly bound to uphold freedom of speech. But in any event, universities should still observe the Human Rights Act in all things, because it will come back to bite them if they don't through the courts, or it may come back to bite them if they don't through the courts. And a really important point in the university context is that where it does apply, Article 10 places academic speech at the very pinnacle of the protection that it provides. Academic speech has what's described as the utmost protection under Article 10, because it's seen as so vital in a democratic society. Political speech also has a very high level of protection, but not quite as high. This is what James Murray, who's a colleague of mine, a solicitor, calls academic freedom of speech. It's not quite the same thing as academic freedom. It's Article 10, freedom of speech, but academic. So it's a lot of different words meaning not quite the same thing. The same words and meaning not quite the same things. It's very, very closely related, and it does give us a clue about how highly academic freedom should be valued. And something we often hear from contemporary activists is that freedom of speech is not freedom from consequences. There is a grain of truth in that, although nowhere near as much as is claimed. Freedom of speech in the Human Rights Act can be subjected to restrictions or penalties, consequences, if and only if the tests in Article 10.2 are met, which I won't bore you with because you can look them up. But there is a test, and there is a limited set of circumstances in which a set of aims which you can be looking to achieve, which will justify restricting speech. And it's not just that any old penalty can be imposed on somebody who exercises their freedom of speech in a way that you can restrict. The penalty itself has to be proportionate, so there's that proportionality principle that I was talking about before. And the only basis on which you can restrict speech under Article 10.2 is where you have a lawful basis for doing so. So it has to be, the way it's phrased in Article 10.2 is prescribed by law, so there has to be a lawful basis for interfering. It means there has to be a domestic law which justifies restricting speech, something like the law of harassment or the law of, the prevent duty. So it has to be prescribed by law, it has to be proportionate, so proportionality will mean something like putting into place mitigations rather than closing a thing down altogether, or allowing some speech and not the rest of it, or various different things that can be done to restrict or put conditions on speech. It's only when speech is completely and utterly beyond the pale that it can be shut down altogether, and that's speech that falls into Article 17 of the European Convention, which is stuff like Holocaust denial or totalitarianism. And that just doesn't attract any protection under the Convention, under any part of the Convention at all. So it falls completely outside that. Everything else you have to engage with it, with these proportionality and prescribed by law principles in mind. So that's Article 10, freedom of speech. There's also a species of freedom of speech under the Equality Act, and this is really important because the Equality Act is accessible. The Human Rights Act is unenforceable by an individual, really, not only for the reasons that I've said a moment ago, that you probably don't have a direct right as an academic to sue your university under the Human Rights Act, but also just because it would be prohibitively expensive. But you can go to an employment tribunal and you can do that on your own. You can do it while you're still employed to complain about being discriminated against or harassed in your employment. And in theory, you won't have to pay the other side's costs if you lose. So it's an attractive option when compared to the Human Rights Act. And also when compared to the Higher Education Freedom of Speech Act, which I'm going to come on to in a while, which has a really sort of complicated and uncertain enforcement mechanism, which ends up in a jurisdiction where you might end up paying the other side's costs. And it's also, the Equality Act is also important here because it's available to academic staff, people who aren't necessarily academic staff. The Higher Education Freedom of Speech Act is only available to academic staff, whereas the Equality Act, people who are non-academic members of the university or students, importantly, can bring claims under it. So what is freedom of speech under the Equality Act? I mean, it's not called freedom of speech, it's called philosophical belief discrimination, or the protection from philosophical belief discrimination. The Equality Act prevents universities from subjecting students and staff to a discrimination because of having a philosophical belief. And these are claims which are really having a bit of a moment in the employment tribunal system at the moment. We've got lots and lots of claims coming through. Used to be the poor cousin, really, but it's not anymore. In order for a belief, I mean, it's religion and belief discrimination, strictly speaking, and from that title you'd think, oh, belief is something akin to a religion, but actually it's much, much wider than that. It's a belief which is, broadly speaking, something which is cogent and serious and cohesive and worthy of respect in a democratic society, a phrase which would be familiar to lots of you, and not incompatible with the human rights of others. So an employer or a university can't discriminate against someone because they hold a belief that falls within those criteria. You will no doubt have heard that initially the tribunal in Maya Forstadter's case held that gender critical beliefs didn't meet that test because they weren't worthy of respect in a democratic society, which was a decision which, you know, can generously be described as the tribunal having fallen into error, as we say, as a result of its head being turned by various arguments informed by contemporary activism. That's the generous interpretation. It was entirely unsurprising that that decision was reversed on appeal by the Employment Appeal Tribunal, which said that not only were gender critical beliefs worthy of respect, gender critical belief being that biological sex is real and it matters, not only was that worthy of respect in a democratic society, but that it actually reflected the current law on sex and gender. And it would be a strange outcome if the current law on sex and gender weren't worthy of respect in a democratic society. I mean, some of us could have told them that before, but anyway. In that case, the Employment Appeal Tribunal also said that a belief cannot be incompatible with the human rights of others unless it falls below a very, very, very low threshold. So again, this is the Holocaust denial and totalitarianism, Article 17 types of beliefs. So many, many, many beliefs will fall within Section 10 of the Equality Act, which is the religion and belief section. Inevitably, in the last month or so, I've been asked to advise quite a lot about public statements made by people about the war in the Middle East. And this philosophical belief discrimination is coming into play there a great deal. Explicit support for Hamas is going to be not a protected belief because Hamas is a prescribed terror organisation. In fact, it would warrant a referral to prevent, apart from anything else. But once support for the Palestinian cause has cleared that hurdle, is very likely to be a protected belief, as is belief in Israel's right to protect itself. So, we've seen the recent events at UKRI, which have prompted some of the most ardent contemporary activists to change their tune on academic freedom and freedom of expression. I won't lie, it has been amusing to see Owen Jones trying on his video to desperately launch a campaign for what he called actual academic freedom, or actual freedom of speech, where he tied himself in knots trying to rationalise a version of freedom of speech which only applies to people that he agrees with, or agree with him, I think it's probably more accurate. And he managed to get, I think, 13 likes in about 24 hours before he pulled the video and shut down the campaign. But on the serious side, the war in the Middle East does raise some really important questions about academic freedom and freedom of speech. And much as it's great to admit that issues which are really important to women and minorities are routinely and blithely dismissed as culture war issues confected by the right, and of no real significance, therefore. It is true that Israel-Palestine is an actual war, not a cultural war. It's a real war, so it does throw into sharp relief the importance of freedom of speech and academic freedom and freedom of conscience. And it is significant that it's prompted UCU and Owen Jones, or the Owen Joneses of this world, to reconsider whether or not freedom of speech might actually be something valuable and important, and might actually be something that the left might think about reclaiming. But I do fear that there is a process of reconciliation to be undertaken there. And on the other side of the divide on Israel-Palestine, as Kathleen Stott pointed out in her recent column in the Evening Standard, I think earlier this week, defenders of free speech on the right seem to have gone a little bit quiet about it. She points out in that article that Rishi Sunak, having earlier this year passionately defended her right to speak about sex and gender at the Oxford Union, was now suggesting that having a pro-Palestinian march on Armistice Day should not happen because it was provocative and disrespectful. Needless to say, provocative and disrespectful protest does not fall foul of Article 10 or any other lawful iteration of the right to freedom of expression through protest. And it's also instructive to look at the IHRA definition of anti-Semitism, which is often prayed in aid in the current context in relation to people's speech about Israel and Palestine. It's a document which is very, very difficult to line up against academic freedom principles and freedom of speech, or various other legal obligations in a way which is workable or lawful. Yet universities were more or less obligated to adopt it by the Conservative government. So on that side too, there is work to be done in properly understanding the near universal nature of the right to express oneself freely, and in understanding the demands that it places on us to tolerate it and to exercise what power we might have in a way that doesn't contravene it. Something we often hear from contemporary activists is that you can hold, for instance, gender-critical beliefs, but you can't express them. You mustn't say them out loud because that would amount to hate speech or harassment. This is simply untrue. Within limits, an employer can't discriminate against people with philosophical beliefs on the grounds that they have manifested that belief, which means expressed it in one way or another. It's a wide concept manifestation of belief. It includes talking about your belief, it includes wearing symbols of your belief, protesting, all sorts of things. When a court or tribunal considers whether an employee or a student has been discriminated against because of their protected belief, they will apply under the Equality Act, they will apply Article 10 principles, or principles from the European Convention on Human Rights, because they're obliged to in the way that I explained earlier. they have to interpret all our law in a way that's compliant with that. But they will apply not only Article 10, which is the freedom of speech article, but also Article 9, which is freedom of thought, conscience and religion. For the lawyers amongst you, I think that Section 10 of the Equality Act, religion and belief discrimination, is basically the implementation of Article 10, but within the limits that it only applies to people whose philosophical belief falls within Article 9. I think that's the way to conceptualise it, but that's quite an airy point. But this came to life in Forstater, in Maya Forstater's case, in which once it was established that her beliefs were protected by Section 10 of the Equality Act as a philosophical belief, informed by Article 9, the case was sent back to the tribunal for them to decide whether her expression of that belief, that sex was real and it matters, was whether her employer had discriminated against her because of her expression of that belief, as well as because of her holding it. And they decided that her employer had discriminated against her on that basis. So, plainly a lie that you can't express your gender critical belief, but certainly the tribunal didn't think that. So I think at its core, Section 10 of the Equality Act, religion and belief discrimination, gives employees and students a right to directly invoke Article 9 and Article 10 principles in relation to the expression of their protected beliefs. And when tribunals are deciding these cases, moving to the employment context now, the university context, now, when tribunals are applying these concepts, they will take account of all of the facts and circumstances of the case. And those facts and circumstances will include the fact that academic freedom of speech, that is, freedom of speech under the convention but by academics, has the ultimate protection, is at the top of the tree, and that academic freedom also is protected by the Higher Education Freedom of Speech Act, or will be next year. So, so those are relevant factors for the tribunal to take into account when it's applying the Equality Act, which might mean that it tips the scale in favour of the person who used the speech which has been contained or for which they've been dismissed or disciplined. So both the Human Rights Act and the Higher Education Freedom of Speech Act can inform a complaint of this sort in the Employment Tribunal, which is why I said at the beginning it might well be a better forum for academics to be bringing their cases in. And those principles as well can also help academics defend themselves against complaints of harassment brought by people who are insulted or object to their belief, their expression of their beliefs, who perhaps complain about something that they've written or said, and complain that it amounts to harassment under the Equality Act. Because in those cases, tribunals, as I said earlier, will have to consider whether in all the circumstances it was reasonable for the victim, the purported victim, to consider that what the person wrote or said was a violation of their dignity. And all those circumstances, again, that the tribunal takes into account in that test include, again, the fact that academic freedom has this gold-plated protection in law. So that is the context within which a tribunal will decide whether it was reasonable for the person to feel violated, because their colleague, published a tweet about biological sex and sport advantage or whatever it is. So in other words, the concept of reasonableness that I spoke about earlier in the Equality Act does actually provide a nuance in the Act which is helpful for recognising or for allowing the tribunal to recognise that the university is actually not a safe space for speech. It's not a safe space for ideas or identities or the other concerns of contemporary activists. So I do think the Equality Act is something to keep an eye on, and because it operates in a way which is logical and coherent, albeit flawed, it is capable of carrying these complaints past the way in which these contemporary activists formulate their ideas. And I think, you know, the freedom of speech is an equalities issue, and we can see that because it's in the Equality Act. And I think it can help to think about it as an equalities issue, rather than seeing it as an enemy outside of equality, diversity and inclusion, and something which threatens equality and diversity and inclusion measures. I think it has to be seen as part and parcel of the duties and responsibilities that arise under the Equality Act, and that universities have a duty to promote under the Equality Act and to observe. Because the reality, I think, is it's not a battle between freedom of speech on the one hand and equality, diversity and inclusion on the other, which is how it's very often characterised. These things are all part of the same ecosystem. What it is a battle between is freedom of speech on the one hand and the version of equality, diversity and inclusion that is promoted by contemporary activists, which is not the law. So I think that's an important way to remember that these things actually are capable of working in harmony. So just moving on to the higher education freedom of speech briefly. Am I at 40 minutes, crikey? Sorry, I won't be long. Okay, I will wrap up. Okay.
Just wanted to let you know.
I thought I was going to be 20 minutes. Academic freedom and the Higher Education Freedom of Speech Act. This helps us in the sense that it gives us pure academic freedom in the law, in a really kind of neat act, rather than where previously it was in the Higher Education and Research Act, I think that's what it was called, where it just didn't have an enforcement mechanism, so it's pretty useless. It's so far escaped, I think, the attentions of contemporary activism, mainly because it's just not enforced yet. So, you know, it's hard to predict how they will respond to it. But the first thing and the most important thing to note about it is that, just like every other piece of law, it will have to be interpreted in accordance with the Convention principles of freedom of speech and freedom of belief. So to that extent, at least, it's likely to be beset by the same types of problems that already exist in the law. It's not going to sweep everything away in a blaze of glory, I'm afraid. I'm not going to go through the section that I had on what it contains, because you can look that up quite easily. But it's, you know, it's pretty straightforward academic freedom principles as they have been for 100 years, and with the addition of some duties on both university governing bodies and student unions to promote or to take the steps that it is reasonable for them to take to secure freedom of speech and academic freedom. That's an important bit, because there's that reasonableness test again. And arguably, this is a stronger duty than the duty that universities have also under the Equality Act, that's called the Public Sector Equality Duty, which is a duty to pay due regard to the need to eliminate discrimination, advance equality of opportunity and foster good relations. So if paying due regard to a need is a stronger duty than, is a weaker duty, a lower order of requirement than taking such steps as it is reasonable to take to secure, I think. So that's another way in which academic freedom duties may prevail over anti-discrimination duties when there's a clash, when this act comes into force. The bit of the act of the Higher Education Act, which has already come into force, is the bit that establishes the Office of the Director for Free Speech and Academic Freedom, which is Arif Ahmed, who I had the pleasure to serve with on the board of the Equality and Human Rights Commission, and I have very, very high hopes for. He will be producing guidance and running the complaints scheme, and that's an important aspect of this act, is the enforcement mechanism. There's a fear that the act, and in particular the way in which the enforcement mechanism impacts on student unions, which is a really new thing, will have a chilling effect, and it just will mean that student unions won't invite controversial speakers. I think there's something to be said for that argument. I can see the scope for it, but I'm not sure how it could have been avoided. other than just by not having student unions involved or not having an enforcement mechanism. So, you know, it is what it is. It's also slightly frustrating that the legal claim that is available under this Act is a civil court claim and not an employment tribunal claim, because I think it sits much more naturally in the employment tribunal. A claim under this Act could be bundled up with claims under the Equality Act and the Employment Rights Act and so on naturally. And it's not a cost-sparing jurisdiction, so it would be much cheaper. But in any event, under this Act, you have to go through a complaints process first. So, you know, all in all, it's not an ideal enforcement mechanism, but it's better than what we had before. And I think the question that arises from it and from the content of the Act is whether this Act will end up just providing another stage for this battle between contemporary activism and academic freedom to play out on. I have hopes that it won't. I have hopes that what the Act will do more than anything else is enforce a cultural change in universities and force them, the leaders and senior leadership, to look at it in the face and make some decisions about how to deal with it in a way which is in accordance with the law. I have seen that happening to some extent already, although that might be a function of who it is that invites me to talk to them, rather than how widespread it is. But certainly the ones who invite me in to advise them seem to be very keen. And so just in conclusion, I just want to say that I think that for real change to happen, the Higher Education Freedom of Speech Act is not enough. There are structural problems in universities that we're all familiar with, which severely compounds the problem that is posed by the inherently authoritarian and censorious nature of contemporary activism. And those include, this is not going to be a popular opinion, but I think the iniquitous position which university HR and EDI officials and professionals and senior leaders find themselves in, where they're buffeted by the actual law on the one hand and then completely erroneous advice from single issue lobby groups on the other, who are fully signed up to contemporary activist ways of thinking and tell them just outright lies about what the law is in order to shift the power balance. It puts universities in a position where they just can't do right for doing wrong. I mean, I feel sorry for anyone who has to manage academics at the best of times, but I think that this is particularly difficult for them, and what it results in, or has resulted in, is contemporary activism being embedded and integrated into HR policies and EDI policies and statements of institutional values which have little or no certain formal status, and it just becomes completely entrenched in the system. And another issue is the prevalence of accreditation schemes, which give you a bauble for doing things in accordance with the way that they want you to do it. Linked to that, the marketisation of higher education. I probably don't need to expand on that. But if students are able to just go online or go onto their satisfaction survey and trash somebody's reputation. The widespread precarity of employment in the sector, which is inimical to courage and the exercise of academic freedom. And finally, just the fact that disputes about academic freedom and harassment can suck the lifeblood out of a university, at least the non-academic, the administration. So there's an incentive for leaders to ignore it as much as possible, so they don't get caught up in these just intractable and endless disputes over it. Because they'd just rather not open a can of worms. And they are disputes which lead eventually to somebody having to decide whether or not it is reasonable to believe that Israel has a right to self-defense, or the Palestinians have a just cause, and so on. Because ultimately, judges and people who judge these things in internal processes have to decide. They have to put their foot in the water and decide, and that is not something which a university HR professional wants to do. So I've come to the end. I don't really want to finish on the negative, so what I will say is that I do think it's a very exciting time for academic freedom. I do think we're through the worst of it, and I think that the more that groups like this one increase awareness in public and vitally demonstrate the diversity of thought that there is within the academic freedom community. Do you call yourselves that? I think you should. The better. really. So well done to all of you for doing this. I have finished now.
Brilliant and insightful talk. Thank you so much, and sorry for rushing you along. So
No, that's fine.
Joy,
I'm sorry that I
we
was.
do need to have a little bit of time for questions. I know Corey's going to have a lot of questions to ask you. So let's open it up. Gentleman here.
Thanks. That was great. It was very
So
great.
could you just hold on a second? We'll get a mic to you. Thank you.
It's working.
Yes.
That's good. Thanks. I very much agreed with your sense that this is rooted in an epistemological break, but I think I want to challenge you to say this is not the way to think about the politics of the current moment, as if contemporary activism is squaring off against Enlightenment reason. I don't think this is the right way to think about it, but I do think that this way of thinking about knowledge does feed into the contemporary activism. It leads, for example, to the abandonment of any liberal principle of self-restraint. So you mentioned tolerance. Self-restraint is the flip side of tolerance, because if we want to express freedom of speech, the people that have the power to suppress that speech must exercise self-restraint. Why doesn't contemporary activists accept that they must exercise self-restraint? Because they don't think of themselves as powerful. Even though they occupy positions of power, they think of themselves as either being oppressed or speaking on behalf of the oppressed. So they occupy structurally the position of the victim, not the powerful person, despite the fact that they may be in fact be persecuting others. And that means they don't need to exercise any liberal notion of self-restraint. They can persecute whoever they like. Now, it seems to me that the characteristic of the contemporary culture war is that both sides want to occupy the victim position. So the left sees itself, the contemporary activists see themselves as being, victims of a right-wing, even fascist government that wants to crack down on them and foments the culture wars and so on. But the right also wants to see itself as a victim of so-called cultural Marxists, of woke academics who've marched through the institutions and taken over the country. And so neither side sees itself as exercising any power. They see themselves as fighting a rearguard action against some mystical other. So therefore, there's no reason for any of them to exercise any self-restraint,
That's a really
any
interesting
tolerance for
thing.
others. So both sides, in a sense, are bought into that. And so in that sense, I think you're a bit too generous towards Owen Jones.
Well,
I think that the left is going through this process of rethinking academic freedom, and the recent actions of the Conservative government show that they are also fair weather defenders, and I think it is because of this culture war.
I think that's a really interesting analysis. And, I don't think I have anything to say in response to it other than it's a really interesting analysis. I haven't conceived of it in those terms, but I think you are right that there is a part of the academic freedom community which does see itself as victims. I think I had in my mind these wonderful people who don't have that sense of victimhood about them. But yes, you're right, that sort of more, well, I'm not going to name names, but yeah, I know who you mean. Very interesting point.
Look to the woman in green and the gentleman in blue next to her. If you could raise your hands there and just get a list of anyone who wants to ask a question.
Thank you. I'm Hannah Quirk from King's. This idea of a protected belief, I'm just wondering, I know obviously that's employment law terminology, but it's always felt odd in an academic context where people have been stating facts and having to claim a belief to get protection around that. Do you think that's helpful or a hindrance to an academic freedom campaign?
Well, the fact that it's called protected
It has to be
belief.
belief.
I mean, it just is what it is, I think, is the unfortunate truth. I mean, I think that it was originally conceived of as being beliefs which are similar to religion but aren't organised religions. And it has expanded over time to include basically political thought. And that's quite helpful. So I think that it's probably not useful to worry about what it's called. and just kind of keep hold of it, because it's a pretty good weapon. I don't think it was intended to include things like gender critical thought or belief in climate change or all sorts of extraordinary things that have become identified as protected beliefs. So I agree with you that it does seem odd. It is an anomaly.
Alan Sokol, UCL. So I have a question about the definition of harassment in the Equality Act. So I'm glad you emphasized the reasonableness criterion, but my reading of the definition of harassment and makes it look like things are much worse than you said, that reasonableness is not a mandatory condition for harassment. It's one of three factors that the court has to have regard to. One is the subjective perception of the alleged victim. One is whether it was reasonable for the alleged victim to feel that way. And the third is the other circumstances of the case without saying which circumstances. And there's no guidance for the tribunal for how they're supposed to weigh these three factors. So I worry about that.
I don't think you need to worry about that. I really don't think you need to worry about that. In deciding whether conduct has the effect referred to, each of the following must be taken into account. The perception of the victim, that's the subjective element. The other circumstances of the case, so that's going to include things like you have a gold-plated right to academic freedom and academic freedom of speech. And then whether it's reasonable for the conduct to have that effect. That must be taken into account. I mean, when a judge is told they have to take something into account, that doesn't mean rubber stamp that you've thought about it. It means take it properly into account and show your working as to how you have input it into your reasoning.
Right,
It's always.
But taking three factors into account doesn't make one of those three factors mandatory.
No, they're all mandatory.
Well, they're all mandatory to be taken into account.
Yeah, they're all
It's
mandatory
not- they don't-
elements of the course of action.
They're not, I mean, it's not mandatory for the reasonableness to obtain, right? The reasonableness could be overridden by one of the other two factors. That's what worries me.
I mean, I have never seen that suggested before. It will always be done in a way which requires it to be reasonable for it to have had that effect. I've never seen it suggested that it's any other way.
Well, that's good. It's true.
I mean, it's one way of looking at it, but it's not the way that judges look at it.
Thank you. Really got a Casey in the room, which he immediately pulls up the relevant section.
Well, I just haven't had
right
it
there.
open.
That's absolutely
Happens
amazing.
to have it open.
So, question here at the front, and then cut to you afterwards.
Michael Ben-Gad, City University. So first of all, I think what you're discovering is that people on the center right aren't as bad as you once thought. But I would say that the dichotomy between right and left isn't always relevant here. A lot of the racial essentialism, okay, I won't use the W word, identity synthesis is the new term, I guess. A lot of it is very reminiscent of the early 20th century. I would like to ask about, I mean, higher education is a little bit unique because there's a lot of elements of compelled speech that we have to deal with. If somebody teaches geography on the basis of the flat earth theory, right, the university would be within its rights to sort of question that. If I were to decide to teach macroeconomics in a language other than English, equally so. And, the problem is, they may use the terminology of anti-discrimination out of the higher, but in essence, what they're trying to make the argument is that if you do not do what we want you to do, then it's a problem that you're not. It's a pedagogical problem, right? You're falling afoul of some standard, pedagogical standard in terms of how you're teaching, and I don't know how we get around that. I'm not sure whether does the law have any sort of options for us in terms of reasonableness?
Yeah, I mean, the law just is never going to require you to behave in the way that requires compelled speech of that sort. I mean, this is what I was saying earlier on, that the way in which university administrations have been told the Equality Act works is not the way the Equality Act works. You know, I mean, you may well find that you're being subjected to demands for compelled speech by your administration. I don't know, I think the city's pretty decent, but from what I understand from last week, but you know, in other places that this might happen. But it's I would have thought likely to be something which has come through you know, some single issue lobby group as a misinterpretation or misrepresentation of what the law actually requires. It really doesn't require them.
I mean, what I'm saying is that it's often is packaged, not
Yeah, it's
according to
packaged that way,
not according to anti-discrimination, but as simply this is the correct pedagogical decolonization, for example. That, you know, if you're not doing it according to that, you're falling short as a teacher.
Yeah, well, that's a matter for you guys. I'm sorry. That's not my thing. You're going to have to sort that one out yourselves. I'm sorry. But all I can say is the Equality Act doesn't make you have to do that. It's not harassment not to do it, which is what may well be being said, that it would be harassment not to do it.
So I'm really relieved to hear that some universities are asking you for advice, Aqua. That's good to know. And relating to that, I think you're absolutely right that the way that EDI departments and structures have been set up has kind of created a monster in universities that is, as you say, is giving false advice about the law and the obvious implications for academic freedom and actually for equalities as well. So my question is, for universities that want to tackle that, what advice would you give them?
Well, for universities, the leadership, or for people in visual academics? For the leadership. I mean, I am not a fan of accreditation schemes. That would be my first. I know that that you're caught between a rock and a hard place on that because of the need to be able to market yourself and get funding and all the rest of it. I do understand that you're in a catch-22 with it. But I think if you must take part in an accreditation scheme, at least don't believe anything that they tell you. That would be a nice starting point. Make your own decision. Take control of your own policies and procedures and your own teaching and learning. Don't let interest groups push you about on those things. These are institutions which have all the big brains. You should be able to do it yourselves. You don't need to be told what to do by people who are outside the institution. I think that's my top tip.
And what about the actual EDI departments and networks?
Well, those are people who need to learn the law for themselves. Really. No, I mean, I've come across, because you have a mix, don't you? You have some EDI positions which are held by academics. So you have like champions who are academic members of staff, and then you have actual professional people in the administration who deal with EDI matters. I don't think there's any excuse for the professional administrators to not have their own understanding of the law. But I've been surprised by the academics who take up these roles and their limited understanding of it. And the one thing in particular that struck me in more than one place is that the person who's appointed to be the religion and belief person doesn't understand that there's a belief aspect to it. They just think they're there to protect people's religious belief. And that's really, really serious because this is a really important part of the law, and it's where academic freedom, or freedom for academic speech and freedom of speech generally is located in the Act. So these people are championing something which is of vital importance in the university, and they have no idea that that's what they're supposed to be doing. So it needs to be better understanding. But it is a very messy legal landscape, as I said. So it's really hard. And I think organisations like this council and AFAF and other, well, I don't know about others. I don't know who else there is. AFAF seems to be spreading its tentacles across the world. are doing a really amazing job in just spreading that awareness and so on. And I mean, when I first looked at, for instance, the IHRA definition and how of anti-Semitism and how that works in law, I went to all the stuff that you produced on that, and that's on the internet. It's really accessible. It's really easy to read and clear, and that sort of thing is invaluable. Just constantly continuing to sort of put out accurate information and continuing to organise and campaign on these matters. I just can't. I mean, I certainly wouldn't sack the whole EDI department.
Why not?
It's against the law, and that's the right to the job. And anyway, I feel sorry for them. As I said, I feel sorry for them.
Hello, thank you. It was a fantastic talk. I just have a very, very brief question. I want to follow on from Alan Sokol's question about process, how things are packaged up. I discovered recently that Eric Kaufman is my next door neighbour, just down the street. And having heard him speak previously and other people working in academia, people seem to fall foul of what I've termed process punishment, which is when the process that people are put through is the punishment in and of itself. And I'm wondering if you can say anything about how that can be alleviated, or are you aware of anyone trying to address that in the law?
Well, not really. I mean, this is not unique to universities, although it is pretty bad in universities as it is in public sector or public sector adjacent organisations more generally. It's not as bad in universities as it is in councils, local councils. I mean, you can be under suspension for 18 months in a council before you get even an investigation beginning. So it's not the worst, but it just isn't unique. I'm afraid that something has happened to employment law over the years, which means that it's becoming increasingly complex, legalistic, and difficult to navigate, and the jeopardy is very high because the risks to an organisation's reputation of losing a discrimination claim in particular are really, really serious and can rebound in funding and other things, and baubles of other kinds. That first started to affect employment tribunals, which used to be flat cap and sandwiches sort of forum where you went in and hammered it out between you in front of a single judge, and everybody shook hands and went away after an hour or two. And now it's a proper court where we have some of the most difficult and nuanced law that there is. And that, I'm afraid, has seeped down into internal policies and procedures and the way in which processes have to take place in order to stand up to examination by people like me in tribunal, where I, will go through every tiny little detail of what's been done. And I mean, I think it's unfortunate that that's the case, but I can't see a way around it. And it is much worse in these particular kinds of disputes which relate to belief and speech and freedom of speech and harassment, because it's all just so messy. The law is so messy, so difficult, and they end up bringing in somebody external to do it. Quite almost always, when it's a serious issue, it's not really capable of being done internally. It needs a specialist lawyer to come in and do it, which is also terrible, absolutely terrible. Shouldn't be the case, but. And it's not really in my interest to suggest a way in which it could be more cheaply and quickly. I would love no, but I would genuinely like it if it was, because I think it is a punishment. It does feel like a punishment, and I've witnessed it firsthand, and it's not funny.
Thanks.
Oh, hi. We're following on from that, the idea of process punishment, which I hadn't heard of. It's a sort of confusing mix of, it feels like I'm in the middle of, I've been suspended for over a year, and it feels like a mixture of incompetence and deliberate, as in that is the punishment. And even just that, really, that kind of decency to whatever somebody's done, to actually have a speedy resolution, I'm sort of lost really as to why universities at least don't want to do that, and why if they bring someone in, externally who's a lawyer, if you're a big institution, why don't you have an employment lawyer in HR to sort of this is what I'm not sure, because it seems to be the people I deal with don't know anything about the law. So I've got my lawyer on one side saying this is ridiculous, this is a banana republic, and but presumably goldsmiths, who it is, think that they're sort of following some kind of process. So I suppose it's just that. Why is that so? It's just following on from what was said then. Actually, why is that so messy and incompetent, or is it deliberately messy? Do you think?
I've never seen a deliberate attempt to spin out a process. I'm sure it exists, but I just haven't seen it. It's usually the simpler explanation, which is it's just a combination of people not having time and not having the skills to deal with it. Usually, I mean, obviously, I can't comment on your own case, and it may be that some people are motivated by bad faith, but these things are complicated.
But when there is so much at stake, you think, why do they listen to lobby groups when anyone can work out quite quickly that the lobby group is telling you something which isn't legally correct? How does that happen? Because people aren't sort of clueless.
People trust them.
But why?
Because they've been trustworthy in the past.
So it's quite a long pattern of using lobby groups, of having lobby groups come in to advise. Is that?
Yeah, it's been going on for years, but also, some of these are groups who've got, built a reputation on which they're now selling themselves as accreditation schemes.
So there's been a shift.
I think there's been a shift. I think public awareness is growing on that. I hope so, anyway.
Thank you very much for your lecture. It was quite cathartic. My name is Roham Alvandi. I teach here at the LSE. I wanted to ask you, there's a sort of grey area which I think in the States the law has developed better than, I don't know, I'm speaking of ignorance, but perhaps better than here in the UK, and that is the kind of requirement for EDI statements when it comes to employment or funding applications or conference participation. And I understand in the American courts this has been challenged now, and it's working its way through the courts. So I'm just wondering, have there been any challenges to that in the UK, and what's the sort of status in terms of the law here?
I'm not aware of it being challenged here as a criterion. You mean for recruitment stage and for promotion and all of that? Yeah, I'm not aware of it being challenged here. It may well have been. I don't know if anybody else is aware of that. But it's certainly something that I will be keeping my eye on as a little thing to add in the case. But yeah, I mean, I can imagine various ways of arguing it from a legal point of view. The thing that springs to mind is indirect discrimination, which would be an interesting claim to bring, a requirement to tick these particular boxes and make these kinds of statements, some of which are actually quite extraordinary. Indirectly discriminates against people with particular philosophical beliefs. I can see it running. The law seems to me to be capable of dealing with it. Perhaps you should bring a case.
Only if you do it pro bono.
We have other questions, but I'm afraid we've
run out of time.
So not at all. It was a wonderful, thought-provoking, open talk, and thank you so much for teaching us so much tonight. We really appreciate it.
Well, thank you.